Welcome to Patent Options Podcast, Securing Intellectual Property Strategies.
Hello, and welcome to Patent Options Podcast, Securing Intellectual Property Strategies with Jamie Sheridan, patent and trademark attorney of Sheridan Law, LLC. I'm your host, Abigail Vaca, and today's episode is From Idea to Protection, Essential Steps for Securing Your Invention. Jamie, thanks for joining me today.
Well, thank you, Abigail.
So I'd like to start with the basics. When someone is calling you for the first time with a new invention, how do you explain the importance of patent protection and the role it plays in their overall business strategy?
That's a great question. So, patent protection in general is to secure your right to exclude others from making, using, or selling your invention. So, the importance for patents, and especially when somebody first calls me, is generally timing. The patent law in the US and outside of the US has certain rules with respect to timing. And so we want to make sure that we explore if patent protection is important and the pathway that one can take. One of the reasons that, the podcast is named Options is because there's not one size fits all pathway for everyone. So I like to, meet with the client or potential client and talk with them about how patent protection may be the right strategy for them. The analog or inverse to patent protection is trade secret protection. And in some ways, trade secrets are much better than patents. And so one would wonder, well, why wouldn't I just get a trade secret for everything? And if you can protect your intellectual property with trade secret, it's generally better to do so. The cost can be less, and the burden on the owner can be less as well. The problem with trade secret is, by definition, it must be kept secret. And a lot of processes, products, all kinds of inventions, once they're implemented, oftentimes a person can, with relative ease, just reverse engineer the invention, and the trade secret, won't provide the adequate coverage that patents will. There's some other things that I generally talk with inventors about, and patent rights are for a limited term. Generally in the US, it's 20 years from the filing date. That's not a hard and fast rule. It depends which type of patent applications are filed and the route that's taken. And, there's issues of cost and renewal and everything like that. So for a lot of inventors, the patent route can be a good route, but it's like any adventure you take off on. It's good to plan and time to where you're going and why you want to go there.
Great, and let's start with the beginning. What are the first steps that you would recommend someone take when developing a patent strategy, especially, again, if they're just starting out in the innovation space?
So for a lot of my clients, the three things that we generally talk about at first are a patentability search, a provisional patent application, and the non-provisional patent application. Starting in the reverse order, the non-provisional patent application is generally what the real patent application that most people think of. That's also called a utility patent application. And starting in that manner, it's generally for somebody who knows what they want, has captured their invention, and is ready to, quickly and efficiently obtain patent rights. The non-provisional patent application is the way to go. For others, the patentability search is really important to look at that because they may not be an expert in their field. And they may not know what prior art, is out there, even if they are an expert in their field, for that particular invention. So the patent prior art is more robust than what most people think about. It doesn't mean that products have been commercialized. Somebody may have thought of something similar and filed a similar patent application. So looking at that can be very important. The provisional patent application is kind of the third aspect that we look at. And the provisional patent application is by no means right for every applicant, but for many startup companies, the provisional patent application is a great lower cost way to start, have some flexibility, and then secure patent rights, in a more methodical fashion. The downside is over a period of time, there always is more cost going the provisional route. So it's just structuring which pathway, again, that you want to take.
So, what would you say are some of the most common misconceptions that people have about patents when they first reach out to you? And how do you help correct them?
So Yeah, with some inventors, they think the patent process may be more like the copyright registration process. And in the US, it's not a registration process, which means it's more detailed. You have to prepare an enabling patent application that has the written description to support patent claims. And those patent claims are reviewed and examined by a US patent examiner who is a subject matter expert in the field of the invention, and a prior art search is done based on those patent claims. It's a very limited process in that the what some of us say the name of the game is the claim. The real focus is on the patent claim, but there has to be support for the whole patent claim. And so the patent examiner is very focused on what claim or claims are presented in the application. And so it's very important to get that right. And it's a relatively engaged process going back and forth with a patent examiner. Fortunately, it's not a one call, like, have the patent examiner understand it and, everything clicks and falls into place. It's generally much more involved in that. Typically, it's about between 4 and 5 patent office actions is the industry average. And we try to keep that lower by providing well-written claims, understanding the invention and communicating that to the patent examiner, and then getting that on file, which saves the back and forth with the examiner, which saves cost and reduces the file history of the patent application.
Got it. So I would imagine your approach with startups versus established corporations would be different. How do you customize a patent strategy for different types of businesses? And what are those key differences in your approach?
With an established company, their patent strategy may differ when they're working on products that are very similar to other products that they have. And they usually will be looking to file directly as a non-provisional utility application, and then foreign file as well directly into specific countries of interest. On the other hand, for a startup company or even an established company with a newer product that maybe doesn't fit in a line of products that they already have, they may be looking to have more flexibility going forward. With that flexibility, they may be looking at the provisional patent application and then PCT, or a patent cooperation treaty, international application to protect rights in lots of countries and keep lots of options open. So, so there's differences there in the pathway, of getting to ultimate patent protection. It doesn't mean if we start out on a different pathway and the other pathway wouldn't have been better, that we can't take some steps and, try to get the type of protection that the inventor is looking for. It just sometimes higher speed and, lower cost are more applicable. And sometimes, having patent application remain pending for a longer period of time and spending money in a different fashion, can achieve some business goals. And so that's what I work with the applicant to make sure that, we're in alignment with those business goals and that they understand the full process and they're able to budget and do their research and development and, capture inventions as they conceive of those and as they reduce them to practice.
So it sounds like building a strong patent portfolio can be a really complex process. How do you guide clients in managing and growing their patent portfolios over time?
It definitely is a complex process. We use specialized docketing software. We work in a team approach. I have a paralegal that helps me as well. And we work with a client to understand their business and their inventions that they are producing, and then provide advice on, when to file additional claims, whether they can be filed in the same pending application or if a new application needs to be filed, or if there's, a different type of protection, such as design patents or trademarks or other types of protection that make more sense, or, as we said at the beginning, keeping their trade secrets protected as well. And so, we look at all those different aspects and focus on the different facets that help them build, their portfolio, their picket fence around the importance of their business that they have.
Okay, so when someone has an innovative idea that could have global market potential, how do you approach the question of international patents? And what factors should they consider early on?
So, with international patents, there's a few things to think about. Cost is definitely one, and timing is definitely the other key component. In terms of timing, an international patent or the application that gives rise to that patent, the basic filing, which could be a U.S. provisional or a U.S. non-provisional filing, needs to be made timely. It needs to be made before there is a first disclosure or sale. The United States generally has like a 1 year grace period. It's not so with the rest of the world. The rest of the world generally requires absolute novelty. So, talking with me or another patent attorney before you launch your product, before you offer it for sale, or before you publish or otherwise disclose, and it could be on a web page or it could be a paper, are all things to talk with your patent attorney about. And those are all complex issues. They're not straightforward. So, earlier is better. The international filings can flow from the early US filings under the Paris Convention. There's generally a year period for that. So these are different years, but can be the overlap, but they're related to different aspects. You could file directly into the regional patent offices or country patent offices that are of interest, or file what's called a patent cooperation treaty, a PCT application, into the US or into other receiving offices. The process for that, is fairly straightforward, but it does add some complexity if you go through with a PCT. It will cost several $1,000s to go that way, but it's helpful because you'll have another year and a half before you'll need to file directly into national or regional countries. So that filing of $4,000 or $5,000 worth of cost can purchase an option to be able to later file in more countries. The other issue to think about is, with costs in the US, a lot of the costs are at the back end with maintenance fee. With a lot of international filings, there's annuities or annual taxes that are due for each country or region that you file in. European Patent Office, the Pan Patent Office, Australian Patent Office. And so there's costs that are ongoing and are generally more expensive than the US, even though a lot of effort goes into the original US application and that used for the additional filing. The other issue that's, can add to cost is whether there's a translation from the English language that needs to be made. And so the timing of that and cost of that, can be important as well. So there's a bunch of matters to explore and budget out, as we move forward through the patent process.
Definitely sounds like there are a lot of pieces. When is the best time for someone to reach out and retain legal counsel, such as yourself, when starting the patent process?
So earlier is always better. Sometimes it is too late, but generally, that's not the case. I recommend, having a call or a video conference or an in-person meeting and looking at the timing and looking at what has been invented, because sometimes the invention may be ready for patenting and it's time to file before there's a disclosure. There may be issues where it's not ready for patenting. Any disclosure should be stalled for a little while, and then meet again when the invention is ready patenting. But the message really is meet with me early and then plan that out. That's much more helpful than waiting a year or two after you've launched and trying to pick up all those pieces and work going forward.
It makes sense. Thank you so much for joining me today. This has been great.
Thank you.
Thank you for joining us for the Patent Options Podcast, Securing Intellectual Property Strategies with Jamie Sheridan. To connect with Jamie, visit www.sheridanlaw.com and please like, subscribe, and leave a review on your favorite platform.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.